So thank you, everyone. As I mentioned, my name is Mark Sweatman. I'm a business development manager at PBI. PBI has offered and been in the location and death audit industry, providing solutions to plan sponsors and providers for over 35 years. I have 20 years experience helping providers as well as plan sponsors mitigate a variety of different participant risks, such as missing participants, uncashed checks, data quality cleanup, as well as death audits. I've also had the opportunity over the years to speak in front of a variety of different industry associations and conferences. Prior to joining PBI, I held several leadership roles, service, and sales roles as well. So without further ado, I'm going to turn over to and give an intro of my co-presenters from Morgan Lewis, both partners. Elizabeth Goldberg. Elizabeth advises clients on ERISA matters with a focus on fiduciary responsibility provisions, prohibited transaction rules and exemptions, and the management of employee benefit plan assets. She negotiates investment-related agreements on behalf of plans and financial services providers, designs, implements, and administers employee benefit plans, and counsels clients on U.S. DOL investigations, plan fiduciary governance structures, ERISA reporting and disclosure obligations, ERISA litigation, and general benefit plan compliance considerations. Liz's work experience includes several years at DOL's Office of the Solicitor. Also with us today is Lindsay Jackson. Lindsay is also a partner at Morgan Lewis. Lindsay counsels broker-dealers, investment advisors, banks, insurance companies, institutional investors, including ERISA plan fiduciaries, and various intermediaries on the standards applicable to designing and providing advisory, brokerage, banking, custodial, and administrative products and service offerings. Lindsay has in-depth knowledge of the developing rules and market practices in the distribution of advice products, services, and offerings to retail investors, including, in particular, those investing through IRAs, SEP, Simples, 403B plans, and ERISA plans. So as part of the agenda today, there's going to be a background on the missing participant issue, overview of the new DOL guidelines, and as well as observations and considerations as they pertain to both plan sponsors as well as providers. And with that, we'll have Q&A, as I mentioned, the second half of the webinar. So feel free to send those questions our way. And with that, I'll turn it over to Liz.
Yes, thank you very much, Mark. So one thing I'll say about our biographies, which I think is relevant for this presentation, is if you couldn't tell from the biographies, I do a lot of work with plan sponsors, including plan sponsors that have been subject to these DOL investigations and are working through how to implement this guidance. And Lindsay does a lot of work with service providers. And so she's here today to talk about sort of the service provider considerations in both these DOL investigations and more particularly implementing this guidance. So with that, I think we can move on to the next slide, which is really the background on this issue. I would assume that most of you joining this call have some familiarity, but just so we're all on the same page, sort of the genesis of this current issue around missing participants is really been a long-standing problem that's been the focus of multiple government agencies that deal and touch on retirement benefits. So it's been a problem for a while that really Congress has been looking at, the GAO has been looking at, and state regulators, as well as the federal agencies, including the DOL. The biggest sort of place where we see this long-standing problem in the retirement space is for long-standing sort of legacy, large and complex defined benefit plans. So, you know, your large pension plans, particularly where they are made up of participants or, you know, former participants that were employees at different other plans or different other employers. Because what we have found is that when you have these large complex plans with lots of sort of participating employers, there's a significant challenge with sort of record retention, but also the fact that under a DB plan, you accrue the benefit often many years before you actually would be eligible to receive the benefit. And so oftentimes we're finding there are significant, like 30, 40-year gaps between the individual's participation in the plan and their current right to a benefit. So this has, created sort of a problem with gaps in records and gaps when people starting their benefits. To be clear, in this presentation, we're using the term missing participants. But one of the things that has become clear over the last few years as this issue has sort of received more scrutiny is that there are multiple different types of missing participants. And particularly for the DOL, which is the regulator here, they view there as being multiple different types of missing participants. And they've sort of expanded their view of what a missing participant is. And so we just want to be clear from the outset that when we refer to missing participants, we're referring to one of many types of missing participants. And here they all are. So as the name suggests, sort of the first category are the individuals that cannot be located. So former employees, so terminated participants that for whatever reason the plan can't, or the service provider cannot locate them. So they have a bad address, or there's a gap in the information for the participant, such as a missing social security number. But then there's also what we call non-responsive participants, sometimes also referred to as recalcitrant participants. And those are individuals who may actually not be missing. The plan or the service provider may very well have a good address for them, but for whatever reason, they are not responding to communications. And in particular, they're not starting their benefits when they are permitted to do so or required to do so. So normal retirement age or required beginning date. The third category is individuals that are likely deceased, but the plan or the service provider, for whatever reason, cannot definitively confirm that. And then there's the category, which is sort of a newly emerged area over the last few years, which is individuals that have commenced benefits. So they've gone into pay, but for whatever reason, their payments are either not processing electronically, or the individual is not cashing their benefits. And so we generally refer to that as an uncashed check issue. There can be many forms of that. It can be the participant themselves, or it can be a circumstance where you have a beneficiary. And then the last category linking onto beneficiaries is circumstances where the participant is known to be deceased and there is a beneficiary that is entitled to receive a continuation of the benefit, but that individual cannot be identified, or if identifiable, cannot be located. And a theme that we're going to see as we talk through the guidance is that each of these different categories is going to present different challenges. So when you have a situation where the individual is in pay, but they're not cashing their check, that's going to create a different set of challenges than just finding a missing person in the first place. And similarly, as we'll talk about, sometimes some of these categories are going to present even more challenges because it's just going to be harder to locate them. And a good example is that when you have an unidentified beneficiary, that's probably the hardest situation because you may not even know where to look or who the person is we're supposed to be looking for. I'm just going to quickly touch on the history here around the lack of DOL guidance and the actions that the DOL has been taking over the last few years. So again, this issue has been around for a while, but it really started to receive attention once the DOL kicked off an investigatory initiative in this area. And that investigatory initiative began around 2014. It came out of the DOL's Philadelphia office, but it eventually spread to sort of nationally. And as I'll talk about in a moment, the initiative looked to see what plan sponsors in particular were doing to try and locate participants that were missing and get them into payment. Now, the funny thing was, even though the DOL was undertaking these investigations, historically there was not a lot of guidance from the DOL as to what the fiduciary responsibilities were in this area. In other words, the DOL had never quite come out and said in guidance, here's the responsibility of a plan fiduciary when it comes to missing participants, and in all 5 categories that we talked about. Now, there was one set of guidance, but it only on its face applied to defined contribution plans that were terminating. And in the context of that guidance, the DOL said when you have a terminating defined contribution plan, if you take these steps to look for people that are missing and to try and get them into payment, you will fulfill your fiduciary duties. The 5 steps were using certified mail to outreach to them, checking related plan and employer records, checking with a designated plan beneficiary, if there was one. Usually there isn't a DC plan, but if there was one. Then using free electronic search tools. So that, what do we mean there? We mean Google, basically. And if necessary, if the facts and circumstances warranted, using search tools that cost money. So a for-cost locator service, a for-cost locator provider. But again, this guidance the DOL has always viewed as instructive to sort of any missing participant issues, but officially it only applied to terminating defined contribution plans. Now, what we see is that investigatory initiative that I mentioned. It began in, well, here we say 2015. It was 2014, 2015. And the DOL really took this initiative and it started examining plans all across the country. And it did so sort of applying that FAB guidance that I mentioned, even though that guidance officially only applies to defined contribution plans that are terminating. The DOL basically sort of applied that to large DB plans and said, this is what you should be doing to locate and communicate with your missing participants. Are you doing enough? And what we found, we could spend a whole hour on this initiative, but that's not what we're here for today. So I will just quickly say that the key points are, even though there wasn't a lot of guidance, the DOL was taking a very aggressive view. And the lens that the DOL was looking at this issue was essentially, you plan fiduciaries should be doing everything you can on an ongoing basis to look for people and to find people. And if you're not, you may be violating your fiduciary duties. And what did they mean by if you're not? If you have any population of people that are missing or are unpaid after their required beginning date or their normal retirement age, you may be violating your fiduciary duties. Plan fiduciaries found themselves being either cited for breach of fiduciary duty or concerned about being cited for breach of fiduciary duty without having any sort of guidelines from the DOL about really what they should be doing and what the law might require them to do. So there was an immense pressure on the DOL. There's a lot of advocacy to the DOL to get them to say something to give plan fiduciaries and service providers some guide rails in this area. And so with that, I will turn it over to Lindsay, because in January of this year, the DOL finally issued some guidance. And Lindsay's going to talk about what that guidance is and what it looked like.
The new guidance comes in 3 parts. And I think for purposes of the presentation today, we're really going to focus on the first 2 pieces. One is the best practices for pension plans and locating missing participants. And then the second is the compliant assistance release, which gives instructions to DOL investigators who are dealing with these investigations. And the first piece of guidance, I think, has gotten somewhat mixed reviews from folks out in the industry. I think it is very, seen as helpful, as Liz said, in getting some firm guide rails out there, but I think also is viewed as raising some potential issues. While the DOL really went out of its way to say that these best practices are just that, just best practices and not requirements, and that the steps that a particular plan takes are really going to depend on the facts and circumstances. I think, we always have a concern that when you have best practices out there, that they could be interpreted more stringently as really what a fiduciary is supposed to be doing in any given circumstances, including both by the DOL in investigations and also by plaintiffs. So I think there are some concerns out there, but overall, I do think it is helpful that at least now we have something in writing from the DOL that applies to both defined contribution plans and defined benefit plans. The guidance here, I think, falls into 4 broad categories. The first 2, I would say, are really focused on stopping problems before they start. So, not waiting until a participant is in pay status, but really having an ongoing process in place to update a participant's contact information and take other steps to make sure that the plan has good data and is kind of keeping track of where participants are so that when it comes time to make payments to them, they aren't missing. The second piece is to have more effective communication strategies. And I think this has been really a broad focus generally at the DOL and with other regulators to start communicating more clearly what an investor's or plan participants' rights are and what their responsibilities are and how they actually are able to get access to their benefits and what steps they have to take to actually get paid their benefits. The third piece is really focused on the missing participant searches. So if we go back to the FAB from 2014 that Liz referenced earlier, you see a lot of the same steps, like using certified mail, using free and commercial locator services, but the DOL added some new potential steps, and some of them I think people have cited as being somewhat problematic. So for example, using social media, publishing a list of missing participants on the firm intranet. Those types of steps I think are maybe helpful in some circumstances, but I think also raise some potential privacy issues and the potential for fraud and identity theft that I don't think the DOL really adequately addressed in putting that piece of guidance out there. And then the last piece is to document procedures and actions. And I think this kind of goes to our core ERISA fiduciary duty, that fiduciaries are supposed to have prudent procedures and go through a prudent process. As always, documentation is going to be kind of key to defending the actions that you take. When you look at the best practices and you kind of do an analysis as to what makes sense for your plan, you really want to document that decision-making process. And if you decide not to adopt a best practice, consider putting it in writing why you made a decision not to do that.
Yeah, I think Lindsay did a really nice job of sort of framing how the first piece of guidance comes to us. Again, as the name suggests, it's the DOL's view of what best practices are. It's not officially a set of requirements, but it's a set of suggestions. And as Lindsay indicated, we probably think that fiduciaries looking at this will want to go through each of the steps suggested by the DOL, consider whether they make sense for the particular plan or if it's a service provider or a service provider, and then document why or why not those steps are applied. The second set of guidance, though, is fashioned as instructions to DOL investigators that are conducting the investigations that I mentioned. But we, actually think this guidance has some relevance, even circling back to that best practices framework, because even for plans and service providers that are not in investigation, if you look at this second set of guidance, there are some suggestions that could come out of it about additional best practice steps. And so for purposes of today's presentation, that's what we want to focus on with respect to this guidance. So I think moving on to the next slide, you'll see in this guidance to investigators, although it talks a lot about what's the purpose of these investigations, what should the investigators be looking for. It identifies things that the DOL views could suggest problems or more specifically breaches of fiduciary duty. And these are the things that I think could be used almost like a checklist similar to the best practices. So what do I mean here? So for example, the DOL identifies that things like systemic errors in the data, inadequate procedures for identifying who in the plan is missing, inadequate procedures for outreach, and inadequate procedures for addressing uncashed checks. So again, although this is about the investigations, it provides a framework for the big picture issues that fiduciaries may want to be considering. And then there are specific examples. So in the instruction to investigators, the DOL identifies things that they think would be red flags. So one of them is continuing to deliver communications to known bad addresses. So I would translate that into, hey, plan fiduciaries, if you have this process of continuing to send mail to addresses you know are bad, you may want to consider doing away with that because the DOL has cited it as a red flag. Similarly, this example at the very bottom of the page, if there is very clearly flawed data, so birth dates such as 1/1/1900 or names such as Jane Doe and John Doe. So I know from my experience with working with plans and service providers that those are often just placeholders, but I think what the DOL is saying is if you have a lot of placeholders like that, you may want to consider putting those lines of data through even higher scrutiny of searches and outreach efforts. You know, again, for our purposes, the key point in this data is it could provide another set of suggestions for designing an ongoing administration program. And so I think then we can move one more slide to the third set of guidance, because we're not going to spend time on this today. We just want to identify that it's out there. And essentially what the third set of guidance is a temporary non-enforcement policy that allows, that signals that the DOL is not going to bring an enforcement against fiduciaries of terminating defined contribution plans or QTAs of abandoned plans that use certain available relief, namely the PBGC's expanded missing participant program. You know, before we get to the Q&A session, we just wanted to identify some high-level observations and considerations about the guidance. So as Lindsay and I have mentioned, I think, you know, what we take from this guidance is we don't view it as a set of requirements, although there is the risk that the DOL or plan or litigants might. But instead, you know, what we think is this guidance provides a set of evaluation tools to use to evaluate the plan's missing participant search program and outreach program. And similarly, on the, as Lindsay will talk about, on the service provider side, it provides a set of framework for evaluation. So I'm going to speak to observations for plan fiduciaries. So we think that you could use this best practices guidance and the second guidance, the guidance to the investigators, to try and identify what are the gaps in our missing participant program. Are we doing everything that the DOL identifies? If not, you know, which of these suggested practices can reasonably be implemented? On the other hand, which ones are going to be challenging and problematic and not work? And I will just say, from my experience working with plan sponsors, many of these practices that the DOL suggested are not going to work for every plan, and they're not going to sort of work. And when I say work, I think it's be reasonable for every participant that is missing, every circumstance. And so we're not expecting that every plan is going to ultimately adopt all of these things. But the key recommendation is, if you can, go through an evaluation and figure out what is going to be reasonable, what is not going to be reasonable, and then document the choices of what you will implement. You know, the next bullet point is an important one. What practices could benefit from a record keeper or service provider support? A lot of these things, in order to be effectively implemented, you know, may be very difficult to administer in-house, and it may be necessary to work with a third-party service provider. You know, certain things that's probably especially clear, like uncashed checks. But even issues around searching for participants, ultimately, you know, it may be that a plan just doesn't have the ability to do this work in-house, and this is going to be an appropriate use of a third-party service provider. But again, whatever is selected to be adopted, it should be documented, you know, the decision-making of what to move forward. And I think a key point is this is a one-time evaluation, you know, the first time, but it's an ongoing process, because that's a message that comes clearly out of the DOL's views. this is not something that can be done once and then forgotten. Instead, it has to be part of sort of the ongoing plan administration. Really quickly before I turn it back over to Lindsay, some of the other things that come out of the guidance is that there's a lot of document review that needs to be done, starting with sort of making sure the plan documents say enough, the SPDs and other communications to participants about their responsibility in helping to provide information, and being clear about when benefits need to be taken and sort of the participant's obligation to update their address. But more generally, a key message, as Lindsay mentioned, one of the key categories is outreach. So it's not just searching for people, it's effectively communicating with them.
So unlike plan sponsors, service providers aren't generally primarily responsible for compliance with these rules because they take steps to avoid fiduciary status. But as Liz mentioned, plan sponsors are going to turn to record keepers and service providers for help with these issues. And because record keepers and other service providers kind of implement system-wide steps to help with compliance, we end up with a kind of a systemic risk across the firm if there are kind of foot faults and issues with how the firm is helping plan sponsors comply with these rules. So, while not primarily responsible, I think taking a look at the new guidance is really very important for service providers, clearly, and kind of taking a look at, what kind of steps what can you support? What are plan sponsors going to be looking for help with? I'll say in my experience helping service providers deal with missing participant issues, the biggest issue we've really seen is inconsistency in the agreements and plan documents and how the responsibilities are kind of defined between the service provider and the plan sponsor, whether they're consistent with what the plan document says, be it a prototype or an individually designed plan, and then kind of vagueness in the actual agreement terms about who's doing what and what is actually going to be done. So I think one of the first steps really, even though not necessarily mandated or even mentioned so much in the guidance, is to really take a look at the agreements and documents that are currently in place and see if there are inconsistencies and if those responsibilities really are clearly defined. I think another area, as Liz highlighted before on the plan sponsor side, is unclear participant communications. And so to the extent the record keeper has taken on responsibility to communicate issues like benefit commencement dates and what happens when somebody is missing and whether their benefits could be forfeited, I think making sure that those communications are very clear and kind of working with the plan sponsor to clarify any issues there is another important step. And then another big area for service providers really is uncashed checks. I think that is one area where there's a lot of risk, because if you don't have the procedures designed correctly, if you have uncashed checks that kind of sitting waiting for disbursement for a long period of time, you can run into issues with float that really do start to raise some ERISA fiduciary issues. Making sure you have good float disclosures in place and really limiting the time that uncashed checks are out of the plan is a really important step to take. And I think there's also kind of a category that you can look at as self-help. So even if you're not really required or by your agreements to take certain steps, I think being kind of proactive in tracking missing participants and uncashed checks and communicating registries with plan sponsors of those issues is very helpful and can kind of prevent any kind of compliance problem that you could be, even if not technically on the hook for as an ERISA fiduciary, could cause some issues for you as a service provider. Doing some periodic coordination with plan sponsors on looking at missing participants and seeing where a plan sponsor has an issue can be helpful. And then also, I think to help with some of the inconsistencies in administration, considering adopting or considering drafting some missing participant policies and procedures that the plan sponsor can adopt may also be a good place to look to make sure that you have a consistent operations with, kind of what the plan sponsor has agreed to do and is looking for. That could be another area.
a few more observations. We've covered this one at length. This is just, again, the warning that although the DOL says that this is not a required checklist, we have the concern that they will treat it as such. Now, that the way we are recommending addressing that is, again, sort of giving consideration to all of the best practices they identify and documenting the decision not to move forward with any of those. And this language in the guidance that we quote here is sort of how I would frame the documentation when not moving forward with a particular process, because what the DOL acknowledges could be a mitigating factor to using one of the best practices are things like cost effect, so they're not requiring the plan to spend all assets to find people. Things like, again, on the cost effective theme, if the individual benefit is so small, it may not be worth expending resources to look for. Things like, and they mention that here in the language, the size of the participant's accrued benefit. And then things like data security, participant identity. Those are the types of facts and circumstances that would be appropriate, I think, to document if a process is not applied. And then moving to the next slide, sort of our last set of observations on this guidance before we move to the questions, including the unanswered questions. There's a few little nuggets in here that are important in the guidance. One of them is regarding forfeitures, because a question we get all the time, and I'm sure we'll get today, is at what point can you stop looking for somebody? And unfortunately, the DOL did not answer that question. They have never acknowledged that there is a natural point where it makes sense to stop looking for someone. But what they did say is that they did acknowledge that if the terms of the plan provide for forfeiture, and the qualification rules set by the IRS contemplate that if you look for someone sufficiently and you cannot find them, that you can, if the terms of the plan permit, forfeit their benefit. The DOL affirmed that, yes, those IRS rules do permit forfeiture. The problem is, though, at the same time that the DOL said that, they said even after you forfeit the benefit, it's a conditional forfeiture. So if the person comes back, you have to reinstate their benefit, which is consistent with IRS rules. But then the DOL went on to say, and while you have conditionally forfeited, you still have a duty to search for that person. So unfortunately, the DOL sort of gave here, but in a way that's still kind of challenging. One last thing is that there was some language in the guidance that recognized that the new electronic disclosure rules could be very helpful in setting up a program of communication, because then you're not dealing, if you have a good email, then you don't have to deal with issues around return mail, in theory, return physical mail. Okay, with that, I think we're going to move into the question session by first, Lindsay, I think, is going to identify a few of the things that we acknowledge are unanswered questions, and we can sort of talk through how we might deal with them in the Q&A session, I guess. But with that, I'll turn it over to Lindsay.
Thanks, Liz. Yeah, I think while this guidance is in many ways helpful and certainly gives us a lot more clarity than we had before, there are lots of unanswered questions, and I'm sure there are more unanswered questions than what we've listed here. So, I think this is just a starting point, really. But, one of the areas is really, as Liz mentioned, there is the ability under the best practices guidance to do a cost benefit analysis and of a particular approach and decide whether or not you're going to, kind of go down one of the roads that the DOL suggests. So, but the DOL didn't really address how you do that analysis. So a question like, how do you handle a participant that you're not really likely to be able to locate? Are you still required to go through this process? And at what point can you say you've done enough? DOL didn't give you very much clarity on that and really left it to an open-ended facts and circumstances determination. Similarly, if the plan doesn't have a lot of resources, what steps are you going to have to take then? Do you still have to go to the point of hiring a commercial locator service to help you with plan participant searches? That's another unanswered question. The issues we raised earlier about how you balance the risk of identity theft with some of these suggestions that you publicize a list of missing participants, even if it's only internal, to the company that has the plan, those are areas that really haven't been addressed by DOL, and I think raised some pretty significant concerns for plan sponsors and service providers. Then we have the other issue of how do you get someone to cash a check who doesn't want to cash the check. I think if you go and look at some of the unclaimed property funds by states, there are tens of thousands of people with small dollar amounts that they just didn't take the time to cash the check because it wasn't worth the effort. But that leaves the person who issued the check kind of in a bind with what they do with it, and how do you actually get someone to take action, and when can you just stop trying. So with that, I think we can go now to the open forum on questions.
What's different in the new best practices guidance from FAB 2014? I mean, high level, there's still a lot of gray. I look at high level, it applies to active plans, DB and DC now, as well as uncashed checks. Any other highlights, Lindsay or Liz?
So I can start, and then Liz, if you want to jump in. I mean, I think the old FAB really was focused just on the missing participant search aspect. And I think this new guidance is really looking at a few more steps that a plan can take in administration to avoid a missing participant issue, including improving communication with participants and doing ongoing work in cleaning up the plan data. And then I think also on the missing participant search side really goes a little bit further than the FAB in suggesting some, I'd say kind of unique and novel ways of locating people, like talking to colleagues at the company where the person worked, or using social media, which really wasn't addressed in the 2014 FAB.
Yeah, the only thing I would add is I think in addition, we got that language from the DOL acknowledging that sort of there could be facts and circumstances, there could be considerations for things you would not need, why you would not need to do things. That kind of language was not really in the FAB, but again, as Lindsay and I have pointed out, query on whether the DOL went far enough and was specific enough.
I think this kind of dovetails a little bit to what you're saying, but are you able to have a different approach in locating and resolving missing participants versus uncashed checks?
Yeah, I guess I could take this one. So I think that, as we said at the beginning, there are different challenges for each of these different buckets. But at the end of the day, if an individual is in payment and they stop cashing their checks, it's almost as if they're a missing participant anew. And the solutions that are probably going to need to apply are probably going to be sort of the same kind of steps as you would take as if they were missing in the first place, unpaid and missing. Because, if the reason they have not cashed their check is that they have died or they have moved, after you establish that the reason that they have not cashed their check isn't just that they are lazy, if you then get in the realm of they have moved or died, then you're basically conducting the same sort of search and outreach you would as if they were, you were in the prepayment stage.
I would say too, though, on the DC side, where plans written where a check is cut if they have less than $1,000, right, which creates a lot of the uncashed check problem as well. Not so much this person's getting a check every month, right? A check was cut and they never cashed it, or it was returned undeliverable. The method by which you might mitigate that uncashed check could be different than perhaps a missing participant. Lindsay, in agreement there?
Yeah, no, I think that's right. I think that the thing that I think is kind of helpful with this guidance also is that in the past we kind of saw the DOL take positions against being able to forfeit checks that aren't cashed to the plan, and I think that gives you. I think that the new guidance really coming out clearly that as long as the plan document kind of permits that practice, there is a new way now to deal with uncashed checks that wasn't there before, that I think is really a lot cleaner than what people were kind of contemplating in the past.
Is there a frequency you see there, like especially with the new the quote that you had there, Liz, I think it was in your last slide, around being able to put these into forfeiture, however, you should continue to locate these folks, right? But even before it gets there, is there a frequency that you see most often with either the provider side, Lindsay or Liz, in addressing missing participants or uncashed checks? That came up all the time with clients of ours that are under investigation, is how often do I do this, right? Or even ones that aren't under investigation. How often should I be looking for missing participants?
Yeah, so I can start with that one. What I see in working with plan sponsors is there is a range. There's really no one size fits all, and so much of it is driven by the plan's resources in terms of personnel, the population, the number of people that fall into one of the missing participant buckets, also who they're working with as their service providers. So different service providers have different practice. So I didn't see sort of one common practice. What I will say, and so then that leads to the question of, well, what does the DOL think has to be the frequency? And unfortunately, again, this guidance doesn't answer that. I can tell you what I heard in the investigations, which is I think the investigators would often come at this at something like, once a year. That was something I heard commonly, but I would by no means endorse that once a year is a required standard, because that's pretty frequent, particularly, and each of these issues will require different frequencies. So, where it might be reasonable to run address searches on a yearly basis, data cleanup efforts, like Lindsay mentioned, might be something that's more like an every couple of year process.
Right.
I should add one caveat to this, though. I did hear often the investigators say, and I think the DOL would agree, it's important that you do something when you initially get return mail, because the DOL views that as a moment where if you look at that moment, you'll have more likely to be successful in finding the individual than if you wait. So does that mean you have to have a process for every piece of return mail? I don't know. It could mean you have to have a process for search every return mail, or it could mean you have some process where every time there's return mail, you make a list, and then, with some frequency, be it every couple months or every 6 months or every year, you engage in a very deep address search. Again, unfortunately, there's no one size fits all answer.
Right.
Yeah, I agree, Liz, completely with that. I do think the one thing that the new guidance did highlight is that a one-time or sporadic effort is not something that the DOL is in favor of, but doing something a little bit more regularly, be it yearly or whatever time period really makes sense given the particular plan and the missing participant issue you're looking at, I think is important to kind of have this be somewhat more of an ongoing effort than, where the DOL saw problems where, a plan sponsor would just make a one-time attempt to kind of clean up an issue. Okay,
we have a few in a bucket here that are, I'll give you the theme. If a participant check has been returned because the participant is not locatable, can the check be removed? Can the check be moved to an uncashed check account in the plan pending reissuance? And if so, must any reissued check include earnings of some kind?
So I would say that, the first step is to see what the plan document says. I think that, always following the plan document is really important. But if the plan document allows for an uncashed check fund, I think that's a fairly common practice. And as long as you continue to look for the participant, I don't think that the DOL would have a real issue there. I think there's, Liz can talk some about the interest issue, but I don't think there's a specific requirement that you pay interest on the funds that have been sitting in the uncashed check account.
Yeah, in terms of that issue, I would agree with Lindsay that if you're trying to decide whether interest is owed, the primary place to start is the terms of the plan and the benefit that's defined under the plan. And beyond that, the DOL, this guidance did not, address interest or say interest needed to be paid.
Okay. Here's one we hear all the time. Is an uncashed check still a plan asset or considered part of the plan if taxes were withheld and now reside in a DDA account? Is it still ERISA?
we just got kind of metaphysical there, I think. So I would say the DOL would certainly view the uncashed check as a plan asset, and I think would be concerned if that check was sitting outside of the plan for a long period of time waiting for disbursement. But I can also see arguments that we've sent the check to the participant. They haven't taken the steps to cash it yet, but we don't have any reason to, assuming that it wasn't returned in the mail, we don't have any reason to think that the participant isn't going to cash it and won't at some point. And maybe there is clearly an argument there that those are dispersed funds and you pay taxes and it's not a plan asset anymore. But I think that it really depends on how you look at that issue, and I think that the DOL is going to get concerned if it's sitting out there for too long.
How about, I've heard this quite a bit over the last couple of years, is the idea of escheating uncashed checks to the states. Not too long ago, you didn't really hear too much about that, but now it's definitely come up the last couple of years for sure. Is that something you're seeing providers doing or plan sponsors doing?
So I think that's an area where we know it's a practice. I think we've always had some concerns with it, just because the DOL has only really condoned it in the context of a terminated plan. There's an old advisory opinion out there where the DOL said that escheating to the state and the state escheat rules is preempted by ERISA because those are still plan assets in their view. The DOL really has not given us much comfort on the practice of escheating, but I think in some cases you can kind of run into conflicts with the state regulators out there. So it's a problematic area. I would not say it's a best practice, but I also, if a service provider or a sponsor was engaging in that practice, we'd certainly defend it.
Okay. Many here around, not necessarily just a missing participant issue, but approaching retirement age, certain retirement milestones, right? What should be done to a population of folks approaching retirement age or a retirement milestone who haven't taken a distribution? I guess this is really the worrisome bucket, right? It's the folks are getting to a point that there could be a potential problem because they don't take a distribution, but perhaps the mail's getting through, right? Nothing's telling the plan sponsor or the provider that it's a bad address. So should something be done on that population, if you will, in order to see whether perhaps there's problems in the participant data that they're unaware of?
Yeah, I can take that one. So the answer is yes. I agree with Mark. Yes, something should be done. That is very clear from the DOL guidance. What is not clear is what is that moment? Is it normal retirement age or is it required beginning date? Because the DOL guidance doesn't address that. And in my experience working on many of these investigations, different investigators had different views. So my takeaway is I think both moments are relevant. Now, I should add one caveat. It starts with the terms of the plan, because some plans do make the required beginning date normal retirement age, but let's assume a more typical defined benefit plan that allows participants to take benefits at normal retirement age, but does not mandate benefits be taken until required beginning date set by the IRS. Okay, so I think both moments matter. But the required beginning date really matters the most, because at that point, if the participant is not commencing, then there is tax consequences for their failure to do so, and potentially even qualification issues around the plan. So yes, what the guidance tells us is that at that moment, at those two moments, and especially required beginning date, the plan should probably have even extra sort of processes and efforts to look for and outreach to those individuals. And if there was reference in the question to the situation where somebody's not missing, but they're just not taking even at required beginning date, and in my experience working with plans, there's sort of two things that are important. Is one, that the plan try, ultimately the plan may not be able to control whether this individual actually, commences, but if the plan tries and documents that it's trying to communicate with this individual. The second thing would be, and when I say try, frankly, I think it behooves the plan to be aggressive at that point in sort of sending frequent communications, maybe trying to get the person on the phone. If you have emailing them. I mean, you really want to sort of try and hound these individuals if you can. The last thing I will say is some plans permit what I call sort of forced commencement. So you default the individual into payment. If the plan permits that, that can be a helpful process for getting sort of those not missing but not responsive individuals into payment.
How can a record keeper TPA help clients with these issues without being a fiduciary?
I'll say,
hear this all the time. Yeah.
I mean, the key there is to get a client direction and follow the client direction. I think there is leeway to take some ministerial type actions, things like issuing reports without triggering fiduciary status, but anything that really is kind of a discretionary activity, you really want to get direction from the plan fiduciary and make sure you're acting consistently with it. I think, really the biggest risks from my perspective in this case is how you handle uncashed checks. I think uncashed checks create a lot of risk for financial services firms and record keepers, because at that point, you or an affiliate is probably holding the money, and what you do with it is really important. But when you're talking about steps like, how frequently you search for a missing participant, I think you do want to be following the plan directions there. But you always do have room to take extra steps to kind of help yourself and prevent problems from happening before they start, particularly if you see a plan sponsor that you think is really raising an issue. You can reach out and, kind of talk to them and ask them about their processes and, maybe help them with giving them some extra reporting and things like that. But, really fundamentally it is following the plan fiduciary's directions.
Okay.
Yeah. If I could say one thing really quickly on that, Mark, one of the things Lindsay and I talked about is I see it on the other side where plan sponsors, I think, get themselves into trouble because they sort of assume, oh, I've delegated this all to, my service provider. And quite often that is actually not what the case by contract or by operation. So I think the key takeaway from all of this is there needs to be a clarity between the service provider and the plan about who is doing what.
Yeah,
Right.
I think.
Yeah. I think clear and open communications between the service providers and plan sponsors and having, good, clear written terms of agreements is really critical here to make sure everybody's on the same page about who's doing what.
Right. Well, we have time for one more. I do want to call out a couple things. We're going to ask a quick poll question before you all leave. You've seen it popped up right there. And then also when you log out, there's going to be a short survey. If you could take a couple seconds to answer that, that would be very helpful for us. Last question. What kind of documentation should plan sponsors maintain when they try to find missing participants? Liz, Lindsay, I know on our end, oftentimes our efforts comes with an audit trail reporting, right? What was the effort? What was the outcome? Timestamp, those types of things from an audit trail perspective for the fiduciary. But what other types of documentation would you recommend when it pertains to missing participants that they should be looking for, a plan sponsor?
Yeah, I think I would say, frankly, as much as you can document, and not to the horn of service providers, but this is where a service provider could be really helpful because, frankly, if you are making any effort, you should be documenting that because the problem with this issue, just to put it out there, is from the DOL's perspective, unfortunately, they have all this stuff about, this is facts and circumstances, but at the end of the day, they really have a mindset that if you have any unpaid or missing participants, you must have done something wrong. And so you almost, as a plan or service provider, come into a defensive posture of having to explain why, hey, even though we have some people who haven't commenced or have some people that are missing, that's not because we haven't tried. And so my answer to your question, Mark, is document as much as you can. And if you need a third party to help you do that, this may be a place to consider that.
Well, everybody, thank you so much for your time today. We hope it was valuable. Lindsay, Liz, thank you both for all of your time and expertise here. We really appreciate it, and we hope everybody has a great day. Thanks for joining.